Okay, it's 9:03 or whatever it is on December 1st, 2023. New year for the county board. Would you call the roll, Amanda?
Bard,
Yeah, here,
Awful, here, sure.
Yep. Okay, do we have a motion to approve the agenda? Mr. Bard. Mrs. Awful, second. All in favor, say aye.
Aye.
Opposed, same sign, that motion passes. Do we have any public here? I don't see any public. Committee chair reports, Madam Awful, Health Committee.
Well, we will have our regular reports and also from animal control and also about the building, I am assuming.
Mr. Bard, I know it's your last meeting and so forth, but do you have any information about what the zoning committee?
well, the department heads will make their regular reports and the committee will be voting on a variance from A1 to RH1.
I know you were at that meeting, does it look like something, good thing to do?
Yeah. Yeah.
Okay. All right. I don't have any chairman comments today. Mr. EMA is not here, he's at some other function. So that brings us to discussion and action on establishing a Facebook page for the county. At the present time, we have a Facebook page for the health department. And I believe the sheriff has one. I guess that's it.
Emergency management.
So,
EMA has one.
EMA, excuse me, okay. So, there was a meeting here, I don't remember the date now, but several weeks ago, where there was a presentation on media, how to handle dealing with the media and that sort of thing. And that's where this came up. Ways by which we can improve our communications with the citizens of the county. We seem to have a problem with newspaper coverage diminishing over the past several years. The newspapers have either gone out of business or, excuse me, don't publish as frequently as they used to. Not everybody listens to the radio anymore, they're too busy or whatever, I guess, I don't know. Anyway, social media seems to be one of the ways that people are communicating, and Facebook is in that mix. I guess there's several other social media outlets, but Facebook seems to be the one that other counties have adopted as well. So I put that on the agenda for today for us to talk about and initiate the action by which we could get a Facebook page established. Obviously, it's probably not an overwhelming task to get it done. However, there's things such as what Amanda has found here that I guess we need to study and learn about as far as what types of things we could put on that page, how they should be presented, how they should be handled, any other governing rules or regulations or guidelines, whatever it might be, that we need to know about. And I think we need to know about them before we make the decision to do it. Rather than after. So that's kind of where we're at. And Amanda says she doesn't know any more than we do, but I'd like to hear what she does know. Because I think she does know more than we do about this subject, so.
I just reached out to our insurance provider through ICRMT, and they provided me with some documentation on the social media policy and guidelines just for us to follow. So as far as our professional use of social media, that just tells us if we're going to be engaging in social media as a representative of the county, how we're to comment on anything on Facebook, to say, we're an elected official, we're a department head, basically recognize who we are before we make any comments, that we need to disclose that information. I know in that meeting that John was talking about, they had discussed that whoever is going to be allowed to comment on anything. That I think is going to be very selective as to who would be allowed to comment. So it does talk about that in these guidelines. As far as personal use of social media, it states that the employer, so Iroquois County, recognizes that you may wish to use social media in your own personal life. The policy does not intend to discourage or unduly limit your personal expression or online activities. I think we discussed that a little bit too, that obviously on your own personal end, you can comment on anything you want. However, I know a lot of personal people tend not to comment on things countywide. So this just has quite a few guidelines to follow when you're representing the county, if you're going to comment on anything or post anything. But I think we're not going to have the Facebook page open for everybody, all employees, to just post what they want on the Facebook page. I think that would be limited to maybe 1 or 2 employees. So these guidelines, I think they were some pretty good guidelines to follow. We can follow those and maybe even add some of our own if we would like to. There were quite a few pages here that I haven't had a chance to read through the entire thing, but this is from the Secretary of State that goes through archives and records management. Obviously, we have to follow FOIA, things like that. So this will be a little more in detail to go through, and I have not had a chance to go through that. But this would also be policies to follow, I'm sure more guidelines to follow, and how to manage the page itself. So we can go through that, but I'll give everybody a copy of this. I did let John know that I would like to talk with the health department. I believe it's Tyler Robinson that handles their Facebook page. Obviously Eric Sacy with EMA. And then I'm not sure if it's Sheriff or if it's Sandy that handles the Sheriff's page.
It's Sheriff.
Is it Sheriff? Okay. See how they set theirs up, see how they handle it, and then we can see about getting ours put together. And then my last question for John was whether it would be titled Iroquois County, or is this just going to be for just the Iroquois County Board? Because since we do have already a page for the health department, we have a page for the sheriff, and we have a page for EMA, do we need one that's Iroquois County, or would this just specifically be for the board itself? So that's something that we have to make a decision on.
Well, I think those are probably all questions that we have to make decisions on, that's for sure. I think that in addition to that, I think the one thing that you brought up about who's gonna be allowed to post on there is another thing that ought to be.
Yeah, that should be very clearly defined.
And I think you can probably get some information on that, again, like you said, from talking to the health department. And of course with EMA is not a whole lot of other people there, but the purpose of what those pages are used for, is my understanding, is another outlet to provide information to people as to events that are occurring or policies or something of that sort, not making political comments or stances on, even saying that, well, the county board is considering buying 800 acres and making a lake north of Watsika. Are you in favor of that or not? I mean, that's not what we want to do with a Facebook page, I don't think.
No.
And or even if that was something that was being considered, to say that we're in favor of this, boy, you gotta vote for it. I mean, I don't think that's what we want the page to do.
It's very informative.
But I think those are things that we need to establish as far as,
Right.
putting this into practice. And I would think that these other entities may have something like that as well already for theirs, but I think that's what we need to find out what they have.
Yeah, like the health department, they will have a lot of, for a while, it was all posting their COVID, the updates. They post a lot of job opportunities, flu vaccinations, flu clinics.
Yeah.
So they post a lot of information like that. So on our page, if we see something informative on their page, we can always share that information on ours. Same with the sheriff's department, if there's something informative on his, we could share that same information on ours. And then if we have something, I can, if I'm the one managing the page, I can let people know in advance, even though it's on our website, we have upcoming committee meetings. These are what our committee meetings are for this upcoming month. This is when our county board meeting is. And we can always have that information on there as well.
I think those are good ideas, but I guess I probably would be in favor of having the county clerk and treasurer, you know, and other people like the state's attorney or whatever, if they have something that they would like to distribute.
How would
I
it,
guess what I'm saying is that any county office that's not EMA, health department or sheriff,
Right.
and even them, like you said about sharing their use, I think that'd be good, but I think all the other county departments, 911, whatever, you know, if they have job opportunities, they have other problems or issues, like yesterday we had a water main break that affected everything, so, you know, we took steps to keep the admin center open. May not have been the best, most comfortable situation for a while, but I think it worked out okay, and it allowed the public to conduct their business. People that may have had a compelling reason to be here to conduct some business. Somebody wanting to get married, somebody wanting to get other records or whatever, buy their dog tags, you know, whatever the reasons are that they come here for, so.
now, my
And I know there were
question.
people that did come here yesterday to conduct business
Yeah.
like that, so, I mean, that to me is another reason for trying to keep the building in operation whenever we can, but that's another example of something that could be put on the Facebook page. Because it would be a way that employees, if we decided to close the center and we posted that right away, that would be another way that employees would know that they don't need to come in that day. On the other hand, if it says it's open, then they know they are expected to come in.
Yeah.
So these are the kinds of things that I think we can accomplish by the Facebook page. In other words, augmenting what forms of media communication we already have. I suppose if we look at a kind of a list of some of the questions that we just brought up, if we can get answers to those questions at our next meeting of this committee, maybe we can formulate a policy and take steps to put it into play.
You have another organizational challenge with Facebook. In order to create a business page, whether it's Iroquois County or Iroquois County Board, you have to have a personal Facebook page first. So which means it's gonna have to be signed up under somebody's individual Facebook page.
Right.
Then you can create Iroquois County Board, whatever the case may be. So if you were to have an employee, let's just say, for example, you use Amanda, she'll create the page under her personal Facebook, and then if for some reason later on she were to leave employment, you would have to make it a very solid point to take that over before that exit.
Right.
What if she already has her own personal page?
That's how she
It's,
do
it's
it.
created underneath of her, so you would actually have to, she would need to log in and then purposefully move the ownership within Facebook to another individual.
No, I'm saying, you said that a person has to first have their personal page before you can create a page for the county.
Yes.
My question is, what if a person already has such a page?
How do you mean, like Iroquois County, or
No,
if they have their own individual, like I have my own individual Facebook.
fine, let's say that we were gonna appoint you to be the instigator and the administrator of the page. You can just go right ahead then and do that, cause you already have a page, is that correct?
I have my own personal one. What I'm saying
You
is,
don't have to create another one, you already have one.
that's correct.
Okay, that's all I wanted to know.
Yeah, the challenge is when I leave, I still own my own personal Facebook page, and again, you already went into the First Amendment rights. But you have to make sure that you have something in your policy that what's gonna happen if that main creator leaves.
Right. Because you won't be able to get into that page.
Well, and I think that's probably something that the health department and the sheriff and the EMA have already crossed. And
Yes,
again,
definitely.
if they have any of that, those kind of things in written policy form that we can, certainly gonna help us just shorten the task of putting ours together, so.
So that's a question too. I have a question, will the public be able to comment on that page?
That I have on my questions because that gets a little, I know on our website, we have comments turned off. Or for anything, we have comments turned off, so that's something for the Facebook page that we need to decide if we want to shut comments off. But
Yeah.
there's times that we would like to respond to
Right.
comments though, but then there's some that comments can get kind of
Negative,
nasty and negative and we
Yeah.
might not want them out there.
Right.
So that's
that's what.
a question that I had on one of my lists as well.
You can rest assured there will be comments like that.
Oh, yeah.
What are you dingbats doing?
Yeah, Roger will be the one that does it.
Yeah, okay, give him hell.
Actually, I don't mind those kinds of things as much as just the fact that it seems like wherever that kind of a opportunity exists, it seems like that the negative comments far outweigh the positive one,
Oh,
because
yeah.
the positive people are just remaining silent, they're happy with everything, they're not gonna make a comment, so all you're gonna hear is the negative stuff.
Yeah.
And that's the problem, because it provides a distorted view of what's going on, so. If you could get a more accurate accomplishment, and you see the same thing, let's say you wanted to buy a new television set, so you go on the internet to see what brands there are, okay, I like this one, then they got reviews done, well, almost always, they may have a couple negative ones, but they're gonna have more positive
Right.
reviews in there to bias you towards their product.
Right.
And again, that's not a fair representation of the situation, so, but that's something I think, that, again, is worthy of our discussion and the decision as to how we wanna handle that, because I'm sure that if we don't allow that, there's gonna be some people who go, oh, you won't allow me to say.
Where's the transparency, you know?
Right.
Sometimes we do need to clear things up, I think.
Well, and if there is no legal prohibition against not having comments, you know, if we say that what is the purpose of that page, is to provide information, not to provide a forum for comments back and forth on issues. That again should be part of whatever policy that we would adopt and how we wanna administer it.
Yeah.
To me, I think a lot of what we wanna do with this Facebook page would mirror what we already have with our website. You know, it's just another way of providing that information. And so the policies and so forth should be somewhat similar.
Right. I just think we'd be opening up a big can of worms if we go with this commenting thing.
We have
And it
enough,
is an information.
we have enough worms as it is.
But then you also need to keep in mind if we are having the comments on there, which is fine, I know the other pages do allow it. But who necessarily is always going to be let's say they're asking questions. That's gonna be an all the time, checking that page all the time to see who's asking questions, who's answering the questions, who's following up with the people that are asking questions. So that's something to consider as well.
I guess another question that I would have is that if you allow comments from people, then do you also have, at some place, have to include your, policy, a description of, you know, okay, you can comment, but don't expect a reply,
Well,
or something of that sort, so that people understand they're not gonna incite a ongoing debate by making a comment.
Because sometimes people will have a question about, you know, where's this at, you know, how do I get there, or something, you know, that kind of a question, you know.
And I think in any event, if you're announcing an event, you're gonna say, for more information, call so-and-so.
There you go.
And I think that's probably the best way to handle those kind of things. And there's enough people, if they wanna make comments, I've received more than my share.
Yes.
They know how to do it, so.
There's a lot of opportunities. Many companies that have social media have a dedicated person for that.
Sounds like Eric's
Eric must
volunteering.
want it.
I said, it sounds like you're volunteering.
I'm simply just putting it out there that there's because of navigating this, there's a lot out there. I mean, especially if you start allowing commenting. I mean, obviously, you have already discussed that you're gonna have probably more the negative path. How or are you going to comment, and making sure that whatever individual is responding to those knows how to respond to it in whatever light the Iroquois County Board wants. So you do have quite the road to go with this. I'm not saying it's a bad thing by any means, but there's a lot to watch out for,
Yeah.
Yeah.
especially when you're dealing with that First Amendment right.
Animal control.
I think if we get a little more research done, and you know what the questions are that we've asked here and so forth, I think we ought to be in a lot better position to make a decision. I would say that probably one thing that we certainly can do as well is that if we go ahead and establish a page, some of the things that we've talked about, such as like with comments, we decide initially that we don't want to allow. That doesn't mean that somewhere down the road we can't change that and allow that to happen. It's a lot easier to allow it later rather than if you allow it in the beginning and then try to stop it, that's a bigger problem, so.
That's true.
Okay, I guess we've pretty well covered that. We've dumped a lot on Amanda, so
What's new?
she's all fired up and ready to go. Final update on sexual harassment training. From what I heard, we're close to 80%.
We are 87% actually.
Ooh, 87.
Yeah,
That's what we were last year.
yeah.
The same people.
We got the same, we have the same naysayers that didn't do it last year, this year.
For the most part, yeah. But a few of them stepped up and got it done.
Wow.
So, I sent out an email with the link and the listing of who still needs to complete it yesterday, I think. So I might get a few more trickling in, and then I also spoke with another department head about getting some turned in, so maybe we can bump it up to 90 before the end of this year, so.
And then we'll turn right around.
Then we'll turn right around and do it all over again. You got it.
Okay, that brings us to really the main purpose of having our meeting today was to try and continue on with our review of the personnel policy manual. I believe we left off at page 38 last time. So that's
39.
where we want to pick up and continue from.
Okay. We left off on page 39, equal employment opportunity. I needed to print this off because it says to see sample policy, however, I emailed them to resend that to me because I didn't see the equal opportunity sample policy in the email. So we're gonna skip page 39 and 40 and go to page, let me see here, we'll skip this policy. So we're gonna skip policy 1017 for now until I can get that resent to me because I don't have that. And go to final pay, which is policy 1018 on page 40. So there's nothing on, there's no comments on that one, so final pay, if we'd like to keep it the same, we can keep it the same. Moving on to general orientation. Some language here that just, instead of on, under purpose, and she's stating take out complete and just put thorough. I don't have a problem with that. So if that's okay, we'll make that change. And then the next policy, which is personnel, harassment, policy 1020. On here, again, there's an attached policy that I requested to get because I don't have the attachment in the email. So, we'll go ahead and pass over policy 1020 until I can get that policy for everybody to look at. So going on to policy 1021, which is health insurance. Under policy, it currently states full-time employees who regularly work 35 hours or more per week are eligible for coverage for themselves and their dependents. The comment on here says, under the Affordable Care Act, large employers with 50 or more full-time employees must offer health insurance benefits to its employees that regularly work 30 hours or more per week.
Is that right?
I'm gonna agree with the lawyer because I don't know, I was not aware of that, so
Well, I don't.
that's something we may need to look at.
Yeah,
I think it might be good for us to double check that. I don't know if are we legally required to do that? Is it gonna affect anything that we do one way or the other? Probably not at this time, but down the road it might.
Okay, and I know we did 35 because that's what the contracts say.
Lawyers make mistakes too, that's
Oh,
why I
yeah,
said
for sure.
it wouldn't hurt to double check it just to make sure.
And we can do that, I will make a note to check that one for sure. Okay, and then, excuse me. Alright, so moving on, underneath health insurance plan, looks like page 45. Alright, so, let's see here. Employees on workers' compensation, and then she added in, resulting from a work injury while on duty for Iroquois County, or on Family Medical Leave Act, leave of absence, taking out resulting from a work injury while, basically flip-flopping that, while on duty for Iroquois County. I don't have a problem flip-flopping the language if you guys don't.
What is she doing now?
So we had employees on workers' compensation or on Family Medical Leave Act, leave of absence resulting from a work injury while on duty from Iroquois County. She's basically flipping that and wanting us to put in employees on workers' compensation resulting from a work injury while on duty for Iroquois County or on Family Medical Leave Act, leave of absence, who already have health plan, insurance, yada, yada, yada. So
They're saying the same thing.
they're saying the same thing.
she's just taking that sentence from the end of here and moving it to the beginning.
Yeah,
Because they can, and I get that, because they can be on Family Medical Leave Act, you know, that wasn't resulting in a work injury, it could be for different things, so. Are we okay with flipping that language around?
Yeah.
Okay. Next paragraph, employees on medical or military leave of absence may retain the medical plan benefits. She's wanting us to take out the rest of that. In accordance with state and federal law, and then it's notes here that under the Illinois Service Members Employment and Reemployment Rights Act, when a public employee is on certain types of military leave, the employer must continue for a period of time to pay its full portion of the premium. Here's the length of the law. So basically taking out, by paying 100% of the premium, 2% administrative costs by the 10th, military services 30 days or fewer, the person cannot be required to pay more than the employee. So she's wanting to take out that language and just simplify it and say employees on medical or military leave of absence may retain the medical plan benefits in accordance with state and federal law. Shortening it.
Yeah, making more sense.
I guess the question that I have on that is what is our obligation? You said we have to continue paying, we have to pay?
Yeah, under the Illinois Service Members Employment and Reemployment Rights Act, because they're a public employee and they're on any sort of military leave, the employer continues, and there's a certain period of time to pay its full portion of the premium.
What is the sense of that? When you're in the military, you have all your medical coverage there,
I don't
whether it's you or a dependent.
I don't.
Why would you have both? If that's what we have to do, I guess that's fine, but it doesn't make sense to me as to why you would have both types of coverage.
Yeah, I don't know.
It's a state law that we do this.
Mm-hmm.
I guess we'll have to do it.
Right, that's what I'm saying, but I don't understand the reason behind having a state law that says that.
There's a lot of state laws I don't agree with.
Yeah, I'm not sure.
Great.
Okay, well, we'll do it.
Illinois School Visitation Rights Act, Policy 1022, under purpose, to provide employed parents and guardians who are otherwise unable to meet with educators because of work conflicts the right to unpaid time off during the school year to attend necessary, she's wanting to strike out education or behavioral conference and just add in school conferences, behavioral meetings, or academic conferences in their children's schools, so I'm okay with that, it's the same thing. Under policy, to comply with the striking out regulation required by the, and then moving on, Illinois School by Visitation Rights Act, Iroquois County Board will grant each employee who has worked at least a half-time schedule for 6 consecutive months and who has children in primary or secondary schools up to a total of 8 hours of school visitation during the course of a normal school year to attend such events as parent-teacher conferences, student counseling, and etc. So shortening the sentence by taking out regulation required by the but then adding in the language who has worked at least half-time schedule for 6 consecutive months.
That makes it longer.
I know.
Is the 8 hours, is that kind of, do we know, is that kind of a standard thing across the state?
I would assume so with the Illinois School Visitation Rights Act, but I have not read that act, so I'm not sure.
It's just, I'm just curious.
Yeah, I'm not sure. You have to read through that. Under policy still, the last paragraph there puts striking out unless employees and changing it to an employee may request and receive prior approval to take paid time off during their school visitation or may make up the time off if a reasonable opportunity to do so exists, otherwise the time will be unpaid. Employees will not be required to make up lost time. Employees will be required to provide proof that the time off was spent in a school visitation. Just some language changes there, it says the same thing in my opinion. Okay, so moving down to Immigration Law Compliance Policy number 1023. Under responsibility, letter B, it is the responsibility of each employee to provide necessary documentation of identity and employment authorization before they can begin work. Striking out citizenship and adding in that, which I agree with, because sometimes they might have a work visa and still not be a citizen, so I get that. Under procedure, the finance department or designee will collect required documentation of, again, striking out that citizenship, adding in identity, employment authorization. I'm okay with that. Same thing for the next paragraph. I was thinking I'm okay with it, so Alright, so under infectious diseases, policy 1024. Under purpose, Iroquois County Board recognizes its responsibility to provide a safe workplace for all employees and customers. Therefore, the nature of an infectious disease and its meaning of transmission will be considered when handling each specific illness. The comment provided states, consider adding a paragraph specific to COVID-19, something along the lines of the following: employees who are experiencing symptoms of COVID-19, who have tested positive for COVID-19, or who have been advised by a healthcare provider or health official to quarantine should stay home from work and immediately contact their supervisor. Symptoms of COVID-19 may include fever, chills, cough, shortness of breath, difficulty breathing, fatigue, muscle or body ache, headache, new loss of taste or smell, sore throat, congestion or runny nose, nausea, vomiting or diarrhea. Appropriate action will be taken to avoid possible transmission of COVID-19 in accordance with current state and federal health guidelines. So do you want to add in that?
Perfect time for
No, okay, I know, it was good timing. Okay, so we will not add in that.
People are overly obsessed with this
Yes.
COVID thing.
Yeah.
It's gonna be around forever,
Oh, yeah.
like smallpox and measles and all these other diseases. So why should we have a policy that just talks about COVID?
Right.
Why not have smallpox and measles
Right.
and tuberculosis and on and on?
I agree. Okay, so under policy, 1, 2, 3, 4, fourth paragraph. Any employee who is diagnosed as having an infectious disease that may be transmitted in the workplace must add in the word immediately, inform his or her supervisor, and taking out within 1 calendar day. I'm okay with that?
Yeah.
No way they wouldn't.
Right.
We're taking out 1 calendar day?
Yeah, and just adding in the word immediately,
Right.
How long is that?
right away,
Right.
less than 1 calendar day.
30 seconds?
I mean, if I have an infectious disease, I'm gonna be calling them probably within the hour to let you know. Responsibility, adding in the legitimate business. So the county recognizes that the employee's medical condition is confidential, therefore reasonable precautions will be taken to ensure information regarding the employee's health is provided only to those persons with a legitimate business need to know. Okay.
That's okay.
Same thing under procedure, taking out the 1 calendar day and adding in the word immediately.
You know, there was a guy in New York City that wanted to go to LA. There was actually 2 of them. One guy got on an airplane and he went to LA immediately. Another guy had a donkey and it took him 10 years to get there, but he still went immediately.
Yeah. That's true. Very funny.
Clever. We could add that in as a side note. For example.
Right.
Alright, so under personnel probationary period, policy 1025, under policy, I'm gonna read the changes here. For all full-time and part-time Iroquois County employees who are now part of law enforcement department, the first 180 days of employment or reemployment are considered to be probationary period. All law enforcement personnel will have a 365-day, 1-year probationary period in which to be trained and evaluated. The extended time is necessary due to prolonged training that may be necessary, for example, police academy. Anytime during this period, an employee may be terminated, taking out for reason without notice, and adding in the language without cause of notice, same thing. Employment is voluntary and employees are free to resign without cause, notice during this time period, without penalty. Employees are not subject to progressive discipline during this period. And she suggested that this next sentence be in bold text. Completion of the probationary period does not change the at-will status of an at-will employee. An at-will employee may be terminated with or without cause or notice of any time during employment, even after successful completion of the probationary period. As stated above, not all employees are at-will employees. Employees who have due process and protections under collective bargaining agreement or pursuant to statute must be provided with written notice of the charges against them, an explanation of the employer's evidence, and the opportunity to consent the charges at a hearing before being terminated.
The sentence, Jill, employment is voluntary and employees are free to resign without cause notice. Should we take out notice? Where she added cause, it shouldn't be without cause notice, it should just be without cause.
Right. I think that she forgot to
That just
perhaps cross that out.
Is there any reason that we need to distinguish, since it talks about a distinction between law enforcement personnel and others? Do we need to identify who is considered to be law enforcement? For example, Sandy Drake is law enforcement.
No, secretary.
He works in a law enforcement office.
Right.
She's not guilty.
That's why I'm saying, is there any reason to distinguish?
I don't know.
Does this mirror the contract as far as the probationary periods?
I think so.
Okay, I wasn't sure.
We don't consider anybody in 911 as law enforcement, and yet they're actively involved in that process.
Right now, their designation according to employment is a secretary at the federal level.
And I'm talking about your employees,
Right. As a telecommunicator, they're classified as a secretary.
secretary.
They are working diligently on trying to get that changed to a first responder at the state level as well as at the federal level. Now, not to mention, their contract already has a probationary period written in. Now, their probationary period is 1 year after training completes.
And that's part of the reason I'm bringing this up, is because there's a difference there. And there's evidence to indicate to me that while some may say it's a gray area, and perhaps it is, they belong to a union that is an FOP union.
Now, in this situation, though, the policy and procedure already identifies somewhere in there that the FOP labor contract or whatever union supersedes this. The only time that this manual would apply is in events where the labor contract is silent. So in case
Why do we have law enforcement personnel in here then? Because every one of them is excluded.
I mean, in this situation, it would be an exclusion, in my opinion. I mean, there's probably no reason whatsoever to have law enforcement listed in there. My suggestion would be if you leave it in there it's not gonna matter. It's not gonna change anything as far as your policy.
Oh, I understand.
I mean, you have extra words in there, basically.
Well, that's my whole point, because right now this is a pretty big manual. Nobody's really wants to read it, and the ones that do read it aren't gonna understand or retain everything in it. And the simpler, the more concise and accurate we can make it, the better or more effective it's gonna be, in my view.
My thought process goes to this. If for some reason, highly unlikely though it will ever be, the FOP labor union for the deputies, corrections, or telecommunicators is ever disbanded, you don't have to update it.
If that happens, we gotta go to do a lot of stuff.
So what if we scrap everything and just leave under policy, employment is voluntary and employees are free to resign without cause during this time period without penalty. Employees are not subject to progressive discipline during this period. Completion of the probationary period does not change the at-will status of at-will employees. An at-will employee may be terminated with or without cause or notice at any time during employment, even after successful completion of the probationary period. All employees are not all employees are at will. Employees who have due process protections under collective bargaining agreement or pursuant to statute must be provided with written notice of the charges against them, an explanation of the employer's evidence, and the opportunity to contest the charges at a hearing before being terminated. And we could strike the whole first half of that, which goes through law enforcement and this and that, because you're basically saying they're covered underneath there.
I think that probably would be a good idea.
Okay.
What do you guys think?
Or-
Mhm.
Hey,
I want her to repeat all that again.
Okay, so
Alright, what do we do?
instead of what the policy currently states, we're gonna change it and basically say that employment is voluntary and employees are free to resign without cause during this time period without penalty. Employees are not subject to progressive discipline during this period. Completion of the probationary period does not change the at-will status of at-will employees. An at-will employee may be terminated with or without cause or notice at any time during employment, even after successful completion of probationary period. Not all employees are at will. Employees who have due process protections under collective bargaining agreements or pursuant to statute must be provided with written notice of the charges against them, an explanation of the employer's evidence, and the opportunity to contest charges at a hearing before being terminated. Okay? Alright, so under responsibility, under B, it is the responsibility of the county board office or crossing out his or her and adding in its designee. Just. Okay, so moving along. Under procedure, letter A, the department head or supervisor will inform new employees of the probationary period upon hire and any related wage practices. She put in the comment here, not sure what this refers to, nothing related to wages in this policy, which
I guess as far as wage practices go, that probably would be something that you would cover when you're hiring somebody. If they wanna know, okay, you're starting me out at $2 an hour, how long do I stay at $2 an hour? And they say, well, after 1 year, you go to 3. And then you get merit raises or you get cost of living raises from that point on or whatever. I mean, people are gonna talk about that.
Sure.
I mean, I don't know whether that needs to be included here, but to me, that's part of the hiring process.
can leave it in.
Yeah.
I can see it both ways, I mean, if there's a certain department that, you know, while you're on probationary period, this is the probationary pay, and then once you have, you know,
Right.
been through that, then you get bumped up or whatever, I'm fine with that, we can leave it in.
Yeah, well, that's kind of what I was saying, you start at $2 an hour, after a year, you go to 3.
Yeah.
Whatever, you know.
Okay, so under,
You don't wanna start at $2 an hour.
No, I want a little bit more than that, John.
Yeah, I remember a day when that was pretty good.
Oh, yeah,
Yeah.
yeah.
I think minimum wage was about $4.50 when I started. Alright, so section personnel, subject investigations, policy number 1026. Under purpose,
There's a lot here.
she is suggesting taking out the entire paragraph and just adding in, the county seeks to ensure compliance with policies and may, in its discretion, conduct an investigation to determine whether any policy has been violated.
Again, as we're saying the same thing, just coming at it from a little
Yeah.
different angle, I guess that's fine.
Under policy, the county may launch an investigation anytime it has reason to believe that a law or policy has been violated. In some cases, including but not limited to cases of suspected harassment or discrimination, the county will investigate any complaint it receives, even if the complaint requests that nothing be done.
I guess I have a problem with that.
Mm-hmm.
Is it our responsibility to launch an investigation anytime we have a reason to believe that a law has been?
That's why she changed it to may instead of will.
Yeah, that's my problem. May means we can maybe turn our shoulder, or, you know,
Mhm.
eye the other direction. don't think that's the right thing to do. I mean, we have examples of where that may have happened for one reason or other. But to me, I think we have a responsibility to investigate. You know, when you say the county, I don't know who, that doesn't specifically say whether it's the county board, the sheriff, the state's attorney, or whomever, but I don't know, I kinda like the idea of saying that we do have that responsibility. That way, you know, if you broke the law, you know what to expect, that there will be an investigation.
So do you wanna leave will in there?
Yeah.
I mean, that's my feeling on it. Others may look at it differently, but,
No, I agree.
I mean, even when you say will, I don't know that 100% guarantees that there will be one, but it sure is a strong indication that there will be or should be. As compared to may.
Yeah, that's kind of ambiguous.
Well, may means that may not happen, it may
Yeah.
or may not happen, and that's,
The last part of that paragraph, it says the county will investigate. It wasn't changed, so
well,
let's keep it.
Next paragraph states, if employees ever at any time have any questions regarding the policy or procedures of an investigation, they should not hesitate to contact the finance department. The county reserves the right to use any lawful method of investigation, which is in its sole discretion, it deems reasonable and necessary to continue whether any employee has engaged in contact in violation of county policy. She wants to strike out warranting disciplinary action and just add in violation of county policy.
why does it say contacting the finance department?
Well, I don't know. I think it's just a case of if Amanda's not there, then,
It used to say county board office.
right, which,
I realize that the two are synonymous in many respects, but then is it better to leave it at county board office or finance office?
everyone did.
I think the first place, you want people to go to you first, or you want them to go to Amanda first?
I don't want him to go anywhere first. I want him just to handle it. Well, in the case that Amanda's not there, cause we've mentioned this before, the finance office pretty much is the county board office, in my opinion. Everything that nobody wants gets put on the finance office.
I understand that there's, like I said, that they're synonymous, but yet there was a time when they weren't quite as synonymous as they are today.
Mhm,
Whether that's gonna continue, it's hard to say.
mhm.
But in any event, when you say county board office, to me, that means I'm going to talk to Amanda. If it says finance, it means I'm going to talk to Joe.
When it says finance office, they're coming into the office where Amanda and Jill and Lacey are, in my opinion. So, I mean, if you want it to be Amanda, we could change it to executive board assistant, but, I don't know, I'm assuming maybe it says finance just in case Amanda's not available and it's something that needs to be taken care of right away.
When Amanda's not available, then you people fill in for one another, I understand that, but if Amanda's not there and you're filling in for her, you're filling in for her as the county board office, not as the finance. That's my point.
Right,
I would rather see it either say county board office or executive assistant.
that's fine, whatever you want. Doesn't matter to me one way.
For one thing, when you're both there and somebody comes in and talks to Joe, and, well, I should be talking to Amanda, it's just a distraction or an interruption for Joe to say, you need to go talk to Amanda, not me.
Yeah, we get that a lot. We get that a lot.
Well, I'm sure you do, and that's part of what I'm trying to eliminate. You guys have enough on your shoulders without having that kind of stuff going on.
It's a good thing we work well together.
Yes, it is.
Employees may be required to participate in an investigation technique such as an interview under certain conditions.
So what are we changing it to? county board office or executive?
Well, I think it needs to be executive assistant, cause there's not a county board office, that's gonna be confusing to
Right.
people.
So
They're gonna go to John's office, in my opinion.
Right.
That's what I think too, is they're gonna go to,
Leave it then, no.
so we'll just put a T.
They can slide it under the door like they did with
Right.
us.
So county board executive assistant?
Yes.
Okay.
Okay, employees may be required to participate in an interview technique such as an investigative technique such as an interview process under certain conditions. She wants to strike out their willingness to participate in this investigation technique is mandatory and failure to cooperate, and add in failure to participate in a required interview with the county may result in disciplinary action up to and including discharge. Says the same thing in my
What's the
opinion.
difference?
Yeah. An employee's failure to answer any questions will be considered a refusal to cooperate with the investigation and may lead to disciplinary action up to and including discharge. I don't have any issues with the changes because they say the same thing, but
No,
Because
see, there's a
there's
case,
the will
there's a
may.
case where I would not object to the may versus the
Yeah.
will though, because that's something in our option.
Right,
To me, there's a difference between, you have to investigate.
depending on each case, I mean.
Could I offer another suggestion here? I'm seeing words in the later paragraph where it says including an action up to and including termination. Doesn't matter to me which word you use, the result's the same, but just to clean it up, to use the same language throughout your document, are you gonna use the word discharge or are you gonna use the word termination?
I said the same thing.
I mean, the result's the same.
Sorry, guys.
I understand your point, it's probably a good one, I probably would prefer termination. I think it's more clear. I don't know, to me, termination.
Yeah.
I prefer the word termination, it's usually a little bit more of a stiff word, and if you're going there, it's probably not a pleasant situation.
Right, well, termination is more of a final thing, in my view.
Yeah.
Terminated, you're not working there anymore.
What's the word discharge mean then? Isn't that the same thing? You're gone?
Yes, it can, but it also can be done, for example, in the military, you can get an honorable discharge.
Okay.
You can get a dishonorable discharge.
True.
Same thing in the employment place. But termination,
Means you're done.
yeah, and it's usually of the dishonorable variety. I mean, I never heard of anybody getting an honorable termination.
All with honor and respect.
okay,
I think to Eric's point, probably termination would be
Right,
a better way, plus clearer and more,
precise.
more final or whatever you wanna call it.
Yeah, has a certain ring to it.
And we say that the one paragraph says disciplinary action up to including discharge, the next paragraph says subject to termination.
yeah, I made a note, I will change that.
So I think
You probably got this throughout your whole document.
termination.
Right.
Alright, the county will take steps to protect the privacy rights of employees interviewed in the course of an investigation interview to the extent permitted by law and to the extent feasible while also conducting a thorough investigation. Conversely, employees, and then it goes on to the next page, who are interviewed during an investigation are expected to maintain the integrity of the investigation by keeping the investigation confidential.
Explain all that, please. It's kind of,
I guess that's fine.
And
Saying they should maintain is not very good.
we should, but you can't guarantee that they won't.
Mhm.
Responsibility, the person responsible for conducting the interviews must have reasonable suspicion that these interviews are involved or have information that is relevant to the investigation. She's basically just saying the same thing, only in different words. The results of the investigation will typically be made available only to those employees with a legitimate need to know. This may be subject to disclosure under FOIA. Sorry,
When they say the results of the investigation may be available, does that need to be clarified as to what the results, what is results? That's like the final determination made by those that have conducted the investigation?
that's how I read it.
Should not include any testimony since that's supposed to be confidential.
No, the results is the final decision is how I read it.
Right.
My question for that is, let's assume there's some level of punishment, whether it's a oral, written, so on and so forth. Shouldn't that still be a confidentiality thing for the employer to employee? I mean, regardless of what happened specifically, how much is FOIA really going to, number one, get involved with? But my opinion is, regardless of whether they were put on a verbal or any other progressive form of management, should that information be released at any time? That, to my understanding, has always been employer-employee privilege.
I guess it depends upon the state laws regarding FOIA, what is FOIAble and what isn't.
That may need to be referred back to the
We get,
insurance and or Jim.
we get some pretty interesting FOIA requests around this place.
I wholeheartedly agree.
Some of them are pretty comprehensive as far as what they're looking for.
I'm just going that confidentiality between employer and
Well,
employee.
it's a difficult situation, I suppose. For example, in the health department, you have HIPAA laws where information is clearly protected, no matter what. We don't have that elsewhere. So then it becomes a matter of, what should be kept confidential and what isn't. If we have an issue with something you've done and we tell you we're gonna investigate it and be kept confidential, and then it's over with, and now here comes some watchdog group that wants to FOIA everything, what do we do?
I mean, there's certain parts under FOIA, I'm sure that, well, we have in the past denied requests, and they're welcome to appeal it through the AG or wherever else they want to go with it.
They go to court too.
They do as well. I mean, it is what it is in those situations, but I mean, we would obviously need the state's attorney to weigh in on his opinion. In this case, Jim, he would be able to review the information and determine if it should be released.
But he's not.
Obviously, we have your insurance company also looking through this, and they would be able to weigh in on an opinion as to why you would deny the request.
But none of those are the final authority.
This is very true. I mean, there's certain times where the attorneys general, I have one example where they said, send us all of the information and we will make a determination. We have no control after that point, once they have the information as to how they disseminate it. And in those situations, obviously, that would be on the employer and or employee to continue to battle that situation to the best of their abilities.
I think for what we're doing here, we kind of have to go along with what the insurance companies are recommending and the terminology and that part of it. And you can see some of these things where they're saying, well, change this around, and we say, well, it's saying the same thing, but if we agree to change it around, it improves our relationship with the insurance company to know that we're adopting their way of thinking or their way of doing something.
I mean, at worst case scenario, my only suggestion would be to maybe reaffirm what the insurance, hey, we've ran into this question, does this change anything for you? And what you believe that the language should be. And it's possible they will say, no, this is what I would suggest, and leave it at that. So worst case scenario, that's my only suggestion on that. Obviously, depending on what situation you're getting on, there's 100 different nuances to your situation. When you deal with FOIA, if they ask for the kitchen sink, we might have to give it to them.
Well, what would it hurt to ask insurance?
You ask the insurance company to look at this and they passed it on to this lawyer, apparently they don't have an opinion. Well, so it's gonna say, whatever that lawyer says, that's what we wanna do. I don't know, I think, like I said, to me, at this juncture, we're probably best to try and follow what the insurance company board is recommending, except, you know, there've been a couple of things we've disagreed with. I think we have good reason to do that, especially since the insurance company really isn't saying what we're doing is wrong, they're just saying we recommend to do it this way. Well, okay, we don't feel we wanna do it that way, so we can still do it that way, and they still have an obligation to support us and all that sort of thing. But what I'm driving at is that when we don't have a reason to strongly object to something that they're presenting, I think it's good for us to cooperate with them and use some of their language as long as it accomplishes the same purpose. So that's kind of what I think, you know, will further enhance our relationship with the insurance company. They're much more likely to help us out if we're cooperating with them than they are if we're either ignoring what they say or being combative with them. I mean, that's human nature.
Okay.
Okay, Jill, we got a little bit more to do here.
Okay.
We got a few more minutes to spend and then we're done.
Let's see. Okay, so C. She's striking C out and changing the language to say, in certain cases, including but not limited to complaints of discrimination and harassment, the county will conduct an investigation even if an anonymous complaint has been received.
But she don't say what the certain cases are.
My thoughts are she's probably putting in certain cases specifically to those anonymous complaints.
Mm-hmm.
Well, we already had in there about an anonymous complaint that we would do something, we wouldn't just ignore it, so.
Right.
I don't, personally, I don't like that. I think if there's a complaint to be made, it's a good idea for the complainant to identify themselves and to keep everything above board. But I guess there could be circumstances where that might not be in the best interest of trying to get things done.
Mhm.
Suppose it depends on the nature of the complaint. So I guess I'm willing to go along with whatever they've said.
Okay.
Still gives us the freedom to handle it the way we want, so whatever.
The comment she has here on the bottom of the page is she does not recommend this as a search of the employee's person and personnel belongings could result in a constitutional claim for unreasonable search and seizure. Under the Fourth Amendment, because the county is a public employer, it must respect the employee's right to be free from unreasonable search and seizure. She has a recommendation with providing employees with a guarantee notice before requiring them to provide information in the context of an investigation where the conduct alleged could result in criminal charges. And she had an example attached, but again, I didn't get the attachment, so I requested them again. So I have that written down to follow up with.
Well, in our case, we don't have lockers or anything, or even
Right.
personal belongings, but we do have computers. How does that relate to?
They're not personal belongings. That's counted.
So
No, but it does say in here, searches of my person, searches of my work area, and then searches of the locker, so is they are consenting to searching the work area, so it could be desk drawers, anything around the work area is what we're asking them to sign.
Yeah.
And they're saying that they don't recommend that we do this.
Yeah, 'cause they could have
And
a
I don't
person
really
about-
know until I read the
Right.
sample Garrity thing that she has provided. I will get that attachment out to everybody as soon as I get it.
I guess, to me, it depends on the nature of the complaint or the nature of the problem. If Roger murdered Barb, we probably wanna investigate all kinds of stuff that he has, you know, we probably wanna gather evidence everywhere possible, right?
But in that situation, you would be dealing with a whole different level of the law. And at that point, that investigation would be containing your investigations department of police, so in this case, state police. So I mean, you'd be dealing with a very different letter of the law there than what your policy and procedure manual is.
Well, I realize I'm using a pretty deep example.
I mean, it's not that your example is bad,
Go down
but-
a wide spectrum from somebody that's accused of stealing a pencil or an eraser to, what I said, so, I mean, where do you draw the line?
Okay, so moving along, personnel
Some
job.
of these questions maybe we can't answer, maybe
Right.
maybe each situation has to be handled on its own merits, but when she's saying, the law says you can't do this and can't do that, wait a minute, how far does that go? You just said, goes to a whole different level, well, it ought to say somewhere where that level is, shouldn't it? Stealing a pencil is a crime the same as murdering somebody.
It is.
The punishment
I'm
is,
still
the
released.
I think we're getting too far into nuance at
You're
that
right.
point. I mean, regardless whether
Her
it's
desk was right.
whether it's a murder or whether it's a theft of anything, I think you probably get a little too far into nuance as to where that line is gonna be. I mean, if they stole a case of pencils, is monetarily very different than a pencil.
Oh, need a pencil.
That's right. I'm using it
I
for
mean, you can make walls with pencils, but anyways, so I think we're getting a little out.
the law
Yeah,
doesn't
yeah,
distinguish
yeah.
that way, Eric.
It does not, and I think that would have to be rated on a case by
That
case
is the whole
basis.
case. The punishment may be different, but there's still a violation.
Okay, moving along. Personnel job descriptions, policy 1027. Under policy, striking out there will be, and typically, the county maintains a job description for each position of employment. I like that one. I like that change.
Typically.
Typically. Sometimes, we've ran across where there's a new position or whatnot that we haven't found any descriptions out there that we've had to, create. So I like that.
I can think of a couple instances where we've done that, but one of the first things we said was we have to create a job description.
Job descriptions will generally include the nature of work in this classification, tasks, desirable knowledge, abilities, skills, education, experience required for the position. Basically move the word generally. Each employee will typically be asked to sign and date a copy of his or her job description upon employment and as revised. These signed copies will be filed in the employee's personnel file. The employee will be given a copy of his or her job description during orientation.
That's okay?
I think it is, yes, because department heads sometimes have different, we don't always get their job descriptions because they're given to them, per contract or whatnot, so. Yeah, I like typically, we're good. Under responsibility, it is the responsibility of the Iroquois County Board to determine job descriptions for the department heads and supervisors.
That's not right.
Okay.
State law does a lot of that.
Huh?
State law does a lot of that.
Mm-hmm.
We don't determine a job description for the state's attorney or the county clerk, and so on. They're all have duties and responsibilities that are outlined in the statute.
But I don't consider them department head or supervisor, I consider them elected
Elected
officials.
officials, yeah. Well, and you can add in.
They are department heads and supervisors though, they
Yeah,
supervise a
well.
department or they're the head of a department.
Well, do you wanna add in unless otherwise stated
I mean,
through statute or contract?
this applies, for example, to Mr. Yergler in the zoning department. It applies to Eric Sacy for EMA, those kinds of people who have come for our performance evaluations here. I agree, that's where that applies. But elected officials
So do you wanna put, it
are coming.
is the responsibility of Iroquois County Board to determine job descriptions for department heads and supervisors unless otherwise through statute or contract?
I think that's probably a good idea.
Okay. It is the responsibility of the department head or supervisor to determine job descriptions within the respective department.
I think that's fine.
Okay, moving down. Letter B, number 1, job descriptions will be reviewed as needed for changes which may have taken place since the last review. The comment made is by whom? So is that gonna be,
It'd be by the people that are responsible for writing them, shouldn't it?
In conjunction with the Policy and Procedure Committee.
No, Policy and Procedure Committee doesn't have anything to do with job descriptions. We don't write job descriptions.
Who does the descriptions? Who writes them?
It says right on the preceding page,
Mhm.
the department head
Department head or
and
supervisor.
supervisors.
All right, then let's put that in there.
We can write a job description for somebody, like I said, for the head of zoning that reports to us, yeah, or, and approve that, so like Amanda or Joe, whatever, that's, yeah, but not,
Right.
we don't approve the job description for the employees in the zoning department. We don't approve the job description for Lacey, who works with Joe and Amanda,
Right.
that's their job.
Okay.
we changed her job description, it just says assist Amanda and Joe with everything and anything they may need. We figured that covered a lot.
As
Yes.
advised by me.
There you go. Alright, so moving along, personnel, jury duty, court appearances, this is policy 1028, under policy. Striking out the sentence or testifying as a witness other than a defendant. Adding in the sentence, absence from duty will be with full pay when an employee is called to testify as a witness in his or her capacity as a county employee or as a party in his or her capacity as a county employee, including necessary travel time. Huh? Okay, so said absence from duty will be with full pay for each day the employee serves on jury duty. Absence from duty will be with full pay when an employee is called to testify as a witness in his or her capacity as a county employee or as a party in his or her capacity as a county employee.
Sure, a lot of words there.
So should that first one, should we draw a line to that first portion and then just use what she has underlined? Did she
But
get
even
that?
what she has underlined doesn't make a lot of sense.
No, that's what I'm saying, it doesn't make sense to me, that paragraph at all.
When an employee is called to testify as a witness in his or her capacity. Okay, so said absence from duty will be with full pay for each day the employee serves on jury duty. Absence from duty
That's
will be
wrong.
with full pay when an employee is called to testify as a witness in his or her capacity. I don't think or as a party in his or her capacity. I think it was said twice.
When somebody is required to serve on jury duty, they're paid.
Yeah.
For that.
Yeah.
In addition, but that pay is less than what they're paid for on their regular job.
Right.
So the pay for their what they should be paid for is their jury duty pay plus the difference between that and their regular pay, so that at the end of the day, they receive the same amount of pay that they would have gotten had they otherwise been working at their job. Is that right? Why
I
should
don't know.
they should not get, if Roger's making $2 an hour and after 8 hours at $16 a day and he gets $8 for jury duty, he shouldn't be getting $24 for that day. He should still get $16.
Right.
8 of it comes from the jury duty, 8 of it comes from the county. That's the way it should work.
And it does say on C, the employee will report pay received for jury duty to the finance department.
No employer is obligated to compensate an employee for time taken off for jury duty in the state of Illinois. You will receive a nominal
We
jury
gotta get
duty
you a raise,
payment
Roger.
Yeah, I
from
know.
the state of Illinois for each day you serve
Not
on
if
the
you
jury as
carry
well as
Yeah.
potential reimbursement.
Needs to go check.
Yeah, if I take care of our boy, then I'll be living off the state.
Could I try it this way, Jill and or Amanda, is this practice being followed?
I've not come across anybody on jury duty.
No, we usually, if they get a notice, they usually get taken off for the jury. Because they are county
Because they are,
employees.
yeah, anybody that I've had with jury duty hasn't had to serve because they
Work
have
for
a
the
job.
county. And trust me, I get pulled, what, like
She's
every
been
3
pulled like
months?
all the time. Jeez.
I do. And Lisa's like, I took you out. I'm like, it's okay, I'm just saying.
So I've not had to.
I mean,
I've
I
had
don't
to
care
do it.
either, I don't care either way, but you just gotta tell me.
Well, and I think that's all well and good, but as far as our policy here,
I think we need to
some
look into that.
clarification of the
Yeah.
pay part of it.
Alright,
Because as
I'm
you
gonna put
described
on
it,
here
that's
that
double
we need
dipping.
further clarification.
Yeah,
That's
We
what I'm
wouldn't
saying.
wanna go to do jury duty then.
And it's been my understanding from employment elsewhere that you don't get shorted. At the end of the day, you combine the two together so that
Yeah,
your pocketbook still receives the same amount.
and then what I just read was totally different, so
And
we'll ask for clarification.
Yeah, that
I
one.
think I've maybe had one, Mary Ann, I think, that took jury duty, but I think I recall her maybe taking vacation
I think so too.
or personal time, so, yeah. it's-
I
but
don't know,
that's
we'll
been a
have to
while.
look into that, cause that's been a long time. So we'll look into
The
that.
other thing, the other thing that plays into it that it says here is that if you're excused from jury duty, you're supposed to go back to work for the rest of the day.
Right.
yeah.
Oh, yeah.
So to me, that goes hand in glove with what we're saying about how you should be paid.
Right, I just think we need more clarification on it, so I wrote that down. So moving on, personnel, leave
Why
of absence,
don't, why don't we end right there?
I like it.
She didn't argue that one.
Page 61, is it, or whatever, what page?
Yeah,
58.
it's policy 1029.
58.
58.
Policy 1029.
I'm looking at the old book here, that's why.
Quick reflections there, John.
Yes, sir, I caught it. Okay, we're gonna pass by on executive session appointments. We've got several appointments that we're gonna have to be making. I'm not gonna enumerate all of them, but at the end of the year, we have vacancies on 911, Board of Health. Not sure if there's more than that, but we have some prospective candidates for some of those appointments. I expect that we'll be making some, but not all of them at the December meeting, so I right now, that's about as far as I wanna go with appointments. If you people have any candidates for any of those positions, I welcome the, I know about them. Still looking for somebody to serve on the IMH board. There's a need for that. Correspondence. We had some correspondence this past month. As usual, some of it is updated. Follow our duty and distribute it anyway.
Usually get this right after.
But it's not gonna be.
This one goes to Amanda after you look at it. That one goes to Amanda after you've looked at it.
I don't even know details of what we're gonna do.
What exactly is this? What is this?
Every year we get an invoice which we pay, and at the end of the year, they send the money back.
Oh, okay, that one.
No, that's UCCI, this is different. This is the one that we get, they always send us an invoice, but we've always opted not to join them.
Yeah,
This is the Illinois Association of County Board Members.
Oh, okay.
That's a different, that's
I
a
didn't
different.
even look at
I
it.
wonder what it is.
Yeah, I don't either.
I think his jury is still out.
These people have on their website, though, they have a good description of the duties and responsibilities for all county officers, including county board members. So if you have a chance to look on that,
What's that again?
Illinois Association of County Board Members.
Because we've talked this time about maybe joining them this time around. UCCI is the one that reimburses us for dues and reimburses us for attending their meetings.
And UCCI is the one that provides our liability insurance through their affiliate ICRMT. Which I'm not sure is a good thing to have that close of an association, but that's what we're doing, so we'll see how it goes. But I'm sorry for not paying close attention.
So we did talk about maybe joining them, I just don't know that anybody's looked into everything they offer.
Well, maybe we should do that, I'm sure they won't mind if we pay this, what, this line if we decide to join.
I can
Where's
see if
it?
I can get something,
Where's the envelope?
I can see if I can get something for the next PMP, some information.
What's this got to do with this? Anything?
What that has to do with is the negotiations that are ongoing, it's something that is a preliminary deal that's always taken in case we do not reach an agreement, it's already, there's a pathway in place to get an arbitrator or mediator, one of the two, or, first mediator, then arbitrator, but that's what that's for.
Okay.
Just so you know that the process is ongoing and so forth. I can tell you that the other day in negotiations, we did reach a tentative agreement on the deputies and the deputies and sergeants. We did not reach a tentative agreement with the correctional officers. Strangely enough, in the past, they've always done the same thing, but this time they wanted to be different. So we're gonna have another meeting on December 19th.
Yes.
I think that's the date, I've got it written down.
The 21st.
No, 21st. 21st at 1 o'clock.
Okay,
But I have something, I think, just not that.
we do not have any claims today.
We were standing here at our door after 4:30 6:30 last night, 4.5 hours past the deadline.
That's one more piece of correspondence
So then
that
what
comes
happens?
every year, it has to do
They
with
have
the
to go to
TIF
finance.
district in
They
Waseca.
go to finance, because we're nice, we won't hold them till next month.
There's a CD inside there too, Roger, so be careful.
Okay.
So will that person be, talked to about doing it?
Well, that's
I've
why I
mentioned
said-
things
that's why I
before.
mentioned it.
You have mentioned it before and they
And
still do it?
I've mentioned it in open meetings. Some departments have gotten a lot better.
Okay, we do not have claims today. Do we have any old business to come before the committee? Do we have any new business to come before the committee? Do we have a motion to terminate the meeting? Mr. Bard, second by Mrs. Ruffle. All in favor, say aye.
Aye.
Meeting is terminated.